255-2447. It was probably blinking and nobody picked it up. Go ahead and try it again. I'm standing here right now. You want me to pick it up? And do what? All right, whenever you're ready, go ahead. Sure.
All rise. Circuit Court CRD NN4 Duval County in the state of Florida is now in session. The Honorable Judge Russell Healy is presiding. Make sure your cell phones are cut to an off position and there's no speaking. Please be seated.
Sure.
Good afternoon, everybody. Good afternoon. First off, I appreciate y'all being here. Sorry about the delay, but originally what we had set for hearing today was Mr. Strolla's. Well, actually, you call him. He's going to appear by phone.
I'm here, Your Honor.
Oh, you are?
I can barely hear you, but I can hear you.
Okay, well, let's see if we can get our IT people to help us with that. And Mr. Dunn is here.
It's on me directional.
Down there and turn the volume up on the.
That'll help with us hearing him, Your Honor, but for him to hear you, you're going to have to speak up because it's so far away.
I'm not a microphone kind of a person generally. Usually people say my voice is loud enough, but there we go. Whoa. All right. Does that help, Mr. Strolla?
Yes, Your Honor.
Okay. So what I was saying was originally what we had set for today was Mr. Strolla's motion for continuance, but because of some other reasons, I amended the notice of hearing and felt that I needed to push this back a little bit to make sure everybody had as much time as they could to be prepared. So our hearing today will be about Mr. Strolla's and Mr. Dunn's motion for continuance of the trial. There is also a motion by Morris Publishing and some other media outlets to set aside some prior orders of the court, direct the clerk to unseal some documents and unredact some other documents, things of that nature. There is another motion along the same lines from Post Newsweek, basically dealing with the same type of issues. The state has responded to that. I believe the defense has responded to that. And then there's also the defendant's motion to determine confidentiality of court records and for protective order sealing certain court records. So in essence, we have two separate issues, if you want to call it that. One is the motion for continuance, and then all the other motions really pertain to the same subject matter from what I can gather. So my intention was to first start with Mr. Strolla's motion for continuance. And so, Mr. Strolla, you can go right ahead.
Thank you, Judge. Judge, basically what I filed is pretty much on the four corners of the documents. The crux of it was, because we're right into the heart of trial preparation, the trial is literally a matter of, days away. There's been some filings, both by the interveners, one being a 16-page motion, one being a 9-page motion, plus there was an emergency motion filed by Mr. Gable, one of the interveners with the DCA. And based on responses and time and research, it's taken away such valuable time of me preparing for Mr. Dunn's murder trial. And it's such a severe case with a massive amount of discovery. It was interfering in proper preparation for him to have a fair and valid defense, pretty much to put it bluntly, Judge, is I've had to dedicate so much time with the media issues and the intervening issues that, of course, didn't start until, I believe, October of 2013. And again, if the trial wasn't set for 2-3 months away, that would be one thing. But here we are literally days away from picking a jury, and I've got to deal with multiple motions from multiple interveners, again, taking tremendous amounts of time away from me representing Mr. Dunn effectively and properly. And I know Mr. Dunn probably doesn't like the fact that I filed a motion to continue. He is very anxious to clear his name and go to trial. I can assure that to the court. I've got to protect Mr. Dunn's rights, and I've got to protect his future with this jury trial. And with everything that's going on, what I would call as an outside distraction, other than the heart of this case and the matter, it's tearing away a valuable time to defend Mr. Dunn properly and effectively. And I felt, in the interest of my client and justice, I had to file this motion to continue. I was not doing it just to delay the trial, Judge. I think we've been set for trial for a couple of months now. And again, if the trial wasn't set for another few weeks away, I don't think I'd file this motion. But when we're literally days away from picking a jury, and I'm still dealing with days and days and hours of handling media motions, it's absolutely interfering with his right to have a fair trial and an effective defense, Judge.
Ms. Corey?
Your Honor, we understand Mr. Strola's position. We too think that it is basically unfair to both sides, that we are trying to deal with the substantive issues of a very important criminal trial, and we're having to stop everything we're doing and deal with not just one motion, but multiple motions, multiple responses, and the like. That is a plague that our colleagues in virtually every other state in the union don't face, nor do federal prosecutors or federal defense attorneys have to stop their substantive work to deal with motions by interveners. So I do understand that. However, this court has had us on a very clear and concise track as far as time goes, with regard to deposition schedule, with regard to motion schedule, with regard to every aspect, every procedural aspect of the trial. And we believe that if the court can resolve these intervener motions today, or at least by Friday, then we would all be able to proceed to trial. Depositions have been taken. I believe there are a few, but those are, but they're just a few left, but those are depots that the state is taking of defense witnesses. We will work with Mr. Strola again with regard to the physical evidence, the photographs, everything we can do to streamline the preparation for trial. And so we would object to a continuance. Our witnesses and our family and the state, of course, has a right to a fair trial too. We're ready to go, and we think it's in Mr. Dunn's interest as well as the state of Florida's interest to go ahead and get this trial done.
Mr. Dunn, I suppose for the record, the motion was not sworn to or adopted by you personally. So I want to, for the record, know if you're joining in the motion or if you recognize Mr. Stroll as filing it but object to it, or are you acquiescing to it?
I would acquiesce, Your Honor.
You would?
Yes, sir. I rely on his advice.
Okay. All right. Well, I'll deal with that shortly, I hope. I guess then we'll move on to the motions that deal with evidentiary matters, discovery matters, things of that nature. And I'm not sure where you want to start. Mr. Stroll has actually filed a motion. I guess, well, the media filed theirs first. So I have two motions, one filed by Mr. Gable, the other filed by Mr. Burke. And I think Mr. Gable's was filed on the 7th, and Mr. Burke's, I think, was on the 9th, if I'm not mistaken.
That's correct.
Is that right? Okay. Generally speaking, basically raising the same or very similar issues. There are some specific references to certain docket entries that are part of the clerk's file, and there are a couple of differences between the two, but in essence, the issue, I think, is pretty much the same. And so, Mr. Gable, Mr. Burke, whoever wants to go first. Yes, sir. Good afternoon.
I'm here on behalf of the Florida Times Union and First Coast News. Our motion had several aspects to it. One was directed toward previous orders entered by your predecessor and by you. The one particularly by you was in August of 2013. The original order, as noted in the defendant's motion or response, was to be a temporary order, 120 days. As it now appears that the media received notice of that motion when it was filed, that order was then continued by Your Honor on August 1 without a hearing, without notice to the media, without any evidence of that would cause imminent harm to the administration of justice, which is the requirement of the Lewis case. And so but the problem is that with these jailhouse calls, the state attorney, and I suppose the defendant as well, are relying on that order to say we have to redact the names of witnesses.
Okay.
And so that's the hitch in producing these records. They said in their papers that they have reviewed all the calls. They've made summaries. We're not asking for the summaries. And so without their having to redact the witnesses' names, they should know if there's any confidential information that needs to be redacted very quickly in there. So I think the appellate court has made it pretty clear, although perhaps it's implied, but in the January 17 order, by the way, they do mention about the ongoing violation of the public's constitutional right of access to public records. I think we had that discussion before. A recognition that, I mean, it has to be a balance, but that there is a constitutional right of access to public records. But they say, quote, "We hereby order the disclosure of all criminal discovery produced in this case, including but not limited to the defendant's recorded conversations," and then made it subject to Your Honor holding an evidentiary hearing if there was a motion filed. And there has been a motion now filed.
Now there has.
Yes.
But that order came out, I believe, well, there was one on December 18 that made some references,
Right.
not as direct as that one.
Right.
It did not address the April or the August orders, which has been represented that perhaps it did. I'm not saying by you, but it did not.
I said implied was what I said.
Right.
Yeah.
And that order that you reference, and I've forgotten the date of that order.
It was Friday, January 17th.
So, and here we are on Tuesday. The difficult thing is, I think what's been portrayed to some extent is that the December 18 order from the district court said something as direct as that when it did not. And once that order was entered, it vacated my order where I tried to, in essence, put a buffer in, which we've talked about, to allow sufficient time for someone to review these calls. Because for the record, it's been represented to me that there are 180 hours of phone calls that have been made, which would obviously take quite some time to go through. So that was the intent, was to put a buffer in there to allow particularly the defense and the state to go through it to whatever detail they needed. But once that December 18 order came down, there was nothing else for the court to do because nobody filed a motion. And it's been discussed that the court refused to do something, and that was not something that I did. I did not refuse to do anything. There was no motion before the court to do anything about. And seemingly, my order, where I tried to put this buffer in there, it was vacated and set aside, so you're back to kind of square one. Now, what happened from there, I now see what you're saying is that, and we'll hear from Ms. Corey and maybe Mr. Strolla, that perhaps part of the reason they weren't disclosed was the April and August order about the civilian witnesses' names and addresses being determined to be confidential. So I see what you're saying.
Yeah, that's my understanding of the reason they've not been produced. And it's not really the April order. That one would have expired of its own terms. It's the August order that continued it through trial. And there is no exemption in the public records law for names of witnesses, addresses of witnesses. And the argument is being made, at least I heard it before, I don't know if it'd be made today, that by releasing the names of the witnesses, that may cause them to be intimidated or somehow. But the depositions have all been taken, as I understand. There's no evidence that the media would intimidate any witnesses. And in any event, they say there are 100 witnesses. It seems like if there's one witness they're worried about, they should say, not just say all 100 witnesses. So this is an interlocutory order. The court certainly has the power to change that order, particularly when it has been brought to your attention that the procedure was perhaps not the right way to do it. And so that's the first part of our motion to set aside the August 1 order. There have also been a number of documents that have been sealed, perhaps because of that order. That may well be it, because it has some names of witnesses in it.
I think that's exactly what it is.
Yeah. So we've asked that those be unsealed and unredacted if it relates to witnesses. And that's essentially what our motion is.
And again, for the record, and I think you alluded to this in some of your filings, we did have, I say we, the state attorney, yourself, Mr. Burke, Mr. Strolla, and I had a conversation at my behest via the phone, I guess it was last week,
Right.
where we discussed some of these particular documents that you referenced, that are referenced in your pleadings,
Right.
Clerk's entries, if you will. And as I looked at those and went through them after I'd had time to review these motions, that's exactly what that seemed to me, that either there are redactions in there of the names of witnesses, or perhaps a document was completely sealed, and from what I can see, seemingly because witnesses' names were contained within the document itself. Mm-hmm. And so I think what was happening was probably the clerk was abiding by the April and the August order and handling it that way. So I hear what you're saying. I think that's what happened.
So okay. Once that August order is vacated, if Your Honor sees it that way, then
that should clear that up.
That should clear that up.
Right.
And having made summaries of all the calls, if there was a confession of some kind in one of the documents, then that can be redacted easily. And we pay whatever the cost is for that to be done. We pay for the cost of the tapes or whatever, which is expected, but not $6,000 to take out the names of all witnesses.
Well, in a minute, you mentioned summaries. A minute ago, you
We're
said,
not asking for summaries.
Okay, you're looking for the tapes themselves.
Right. No, that would be their work product.
Right. Okay.
Yeah.
And again, for the record, this issue has been quietly ongoing. Well, now it's not so quietly, I guess, but it's been ongoing for quite some time because the state listed these calls in their discovery documents several months ago, and the media requested copies of those pursuant to public records laws. And I've been made aware of the fact that there were correspondence back and forth between the state and the media regarding procedure on how to go about it and funds that would be required and such as that. And it seemed to me that, obviously, from what I gather, no monies have changed hands to pay for these things. And it seems like there's a dispute over maybe how much it should be or what's reasonable or to what extent the state has to go through these records. And that's been a little bit lost, I think, not only with the public but in the appellate court, that there was just a log jam there, seemingly, between the media and the state as to how and what the state was required to do pursuant to the Florida statutes as it relates to the public records, and have somebody review these things. So,
well, Your Honor, one exemption in the public records law is an order of the court. And that apparently is what they're relying on, is the order protecting the names and addresses of the witnesses. And since they've already been through all the tapes and that requirement would be removed, then they should just turn over the documents.
I tend to agree with you. I got the impression, and we'll hear from Ms. Corey about it, I got the impression that it was more than that, but I guess we'll hear that in a moment. Thank you, Mr. Gable.
Thank you, sir.
Before I go to Ms. Corey, Mr. Burke, do you want to add anything to that?
Yes, Your Honor. Thank you. Good afternoon, Judge Healy.
Good afternoon.
May it please the court?
Yes, sir.
A couple of points. We are asking for the summaries, or at least an in-camera examination of the state summaries, because without knowing what's contained in the summaries, we can't make a determination of whether it's work product or simply factual descriptions of the tapes. Work product protection, of course, wouldn't apply to simply factual descriptions, is our position. And the review of the tapes, Your Honor, the state has now, as I understand it from prior hearings, gone through the tapes for evidentiary purposes to determine which tapes might be valuable to the state's case as a matter of evidence. And in doing so, they would have made the same analysis as the public records review, which would be for instance, determining whether there are any adverse admissions or confessions contained within the tapes. Certainly, I would expect the state would, if they found a confession within the tape, or even just a mere adverse admission, they would want to introduce that to the jury. So in that sense, we believe the state has already gone through the exercise, at least for that purpose, without regard to the civilian name, reviewing the tapes for the civilian names. So because of that, in the summaries, I might tell the court, might tell us what is contained in those tapes, at least in the way of a possible confession or substantive confession, if one exists. That should, if nothing else, reduce the cost to the media of obtaining the recordings.
Okay.
And if I might, Judge, we join in with Mr. Gable's clients on the redactions by the clerk's office.
Correct. Yeah.
I know they're being very diligent in trying to comply with the law. We just think they've gone too far.
Okay.
Your Honor did ask at a prior meeting for an example of what the public, I believe, sees on the docket versus what I might see. And I do have copies of.
Okay, that'd be great. And again, for the record, that was something that we discussed in the phone call we had last week. That was impromptu, and there was not a court reporter that could take it all down. But one of the concerns that I had is the court gets to see, I guess, everything on this clerk's screen. As I understand it, then some things are restricted and perhaps only lawyers or lawyers that are parties to the particular case could see it. And when I say it, they can go online at home and remotely see these things. And then the general public has another level of entry, if you will, to the system. And so sometimes when these things are being discussed, I'm not clear on what you're seeing because it's different than what I'm seeing. I get to see the unredacted. And so I just wanted to kind of see how it shows up on the screen for you so I'd have a sense of how to rectify it.
Your Honor, if I could explain this, I've handed you two documents. One is legal size, the long one, and one is just 8.5 by 11. The legal-sized document is, they're pictures, screenshots of what I was able to look at this morning. And they show on the right-hand side of each page, if there's an image associated with a docket entry, there's an S, and I'm not sure exactly what the S stands for, or there might be an R, which indicates some level of redaction or sealing. Then on the short form, do not appear to be, and I believe this to be correct from my client, there do not appear to be images shown on the short form.
I see.
And I think the point was raised when this all was discussed, that in the text of the docket, there's no way to know if a document has been sealed entirely or redacted in part, or by whom or what particular exemption.
The general public wouldn't know that.
That's correct, Your Honor.
So this letter size is kind of the general public's view, and this legal size would be the attorney's view.
I believe that's correct. It's, the legal size is definitely the attorney's view, because I pulled it up, and I believe this shorter one is what the public would see.
I see. All right. Any objection to making these a part of the hearing in the record?
No, sir.
None from the defendant, Judge.
I'm sorry, Mr. Strolla?
No objection from the defendant, Judge.
All right, then the legal size would be, we'll call it
The attorney view, perhaps?
intervenor, which, I mean,
Post Newsweek?
Post-Newsweek, we'll call it intervenor Post-Newsweek's Exhibit 1, and the legal size will be intervenor Post-Newsweek's Exhibit 2.
Thank you, Judge.
I'll give those to the clerk.
Just for Mr. Strolla's information, I have handed copies of these two documents to Mr. Dunn.
Thank you.
All right.
Thank you, Judge.
Mr. Strolla, would you want to go next?
Sure, Your Honor. Judge,
I mean, you can
did
you
follow-
can not only respond to their motions, but you can kind of go ahead if you want, dovetail in your motion, which is really about the same subject
Yes,
matter.
Your Honor. I did file a response, and if you refer to the legal argument section, Judge, I think what keeps being lost here, and I understand that Mr. Gable and Mr. Burke have a duty to their clients, but what their clients don't have is the right to supersede my client's constitutional right, where we are trying to prevent a serious and imminent threat to a fair, impartial, and orderly administration of justice in this trial, which there's Supreme Court of the United States case law that says that in a criminal defendant's case, we have to secure that right to a fair trial. The defendant is entitled to receive a fair trial, including the state attorneys, and is entitled to their fair trial for their alleged victims and witnesses, and that cannot be superseded. And I believe it's the McCrary case, which is 520 Southern 2nd, and I have it at 34, Judge, which is from the United States Supreme Court, and it indicates, excuse me, there is no conflict between the statute and the constitutional authority of the judicial branch to take such measures as are necessary to obtain orderly proceedings and a fair trial. And here, the only thing I keep hearing from the media, Your Honor, is we have a right to look at it, we have a right for the public to know what it says, know what it does, regardless of how that may affect the outcome. Not one single attorney from the petitioner has included that this will not harm the defendant, that this will not harm the state. And that's the most paramount factor in this. And it's the responsibility of the court to balance that. And the minute Your Honor believes that this may impede to have an impartial jury seated in Duval County, where we're days away, you have to deny their motion and not only grant the motion for protective order, but decline the fact that they want you to set aside orders that they never even objected to until, I believe, 60 days after the August order, Your Honor. And by them saying they never got public notice, I think it's almost ironic that they represent the media, and the media has been at every single hearing since Judge Bass, to Your Honor, including a plethora of media outlets filming an indigency hearing, which you almost never see in any case, but to have 15, 20 cameras. And just to add to the fact, Judge, I filed my motion for continuance on January 17th at 11:43 a.m. The only parties given notice and access to that motion were the interveners' counsel, the state attorney's office, and myself. And within 15 minutes at 11:57 a.m., news4jax.com by Christopher Yazbez, Y-A-Z-B-E-C, not only had a full published printed article, but actually had a completely unredacted copy of the motion attached to it. So again, they're talking about how the state's already reviewed some of these phone calls. In fact, I haven't reviewed all the phone calls. We're talking about hundreds of hours where not only do I have to sit and listen to what he says, but I've got to take critical notes. And in fact, Judge, to be candid with the court, I'm in the process of filing motions in limine for this Friday to actually try to preclude and exclude some of the comments the state may or may not want to use, as one, they're not relevant, and two, they're 403 overly prejudicial, even if Your Honor found them relevant. And my concern is, if the media thinks they're entitled to this complete audio listings, which I don't think the DCA, or I submit to the court, the DCA did not say the April and August orders are invalid. And in fact, I asked them to clarify their order, Judge, in emergency response, and they declined to touch on that, to clarify the April and August 2013 orders. One, the petitioners are out of time to argue it, but for them to say they didn't get notice, not only does Mr. Franza submit proof that they did, but their own clients are sitting in the courtroom recording everything that Your Honor said in August of 2013, but then they come in October and say, well, Judge, we had no idea. We had no idea you were going to do this, even though they had 30 days to appeal it or do a motion to vacate, and they did not. So I don't believe they've timely filed anything to ask the court to vacate it. I submit to the court the DCA did not vacate those orders. And even if, that being said, my pending motion for protective order, Judge, I think the court can take judicial notice of everything that's been done and posted in this case by outside parties, not the state attorney's office, not the defense, that is going to prohibit Mr. Dunn getting a fair and impartial trial in Duval County within the next 14 days. My point to the court is, if something gets out that should never be even relevant to court, whether the media thinks the public should know about it or not, if that interferes with an impartial jury, then the U.S. Supreme Court kicks in, and they have no right to dispose that or give that out or expose it to the public. And that's where the defendant has a fair trial supersedes anything the petitioners have argued or cited as case law or statute. They're just saying we're allowed to have it, but they're not saying it's in the best interest for the media to put it out there unfettered. And I think that's the point that's been lost in all this, is my client's right to a fair and impartial jury trial in Duval County. And if this gets out to the media and they get to spread it like wildfire, where even I haven't been able to review 100+ hours of it, that's going to inhibit it or prohibit it. And then now I've got to file motions, Your Honor, again, which interfere with his defense for a change of venue. And that's what we've been trying to avoid, Your Honor.
Thank you, Mr. Strolla. Ms. Corey?
Yes, Your Honor. If I may, I have to point out the irony of the media lawyers who instruct their clients on a daily basis to edit their work product, to make sure they don't just take everything down for a particular story and air it all or print it all, because they have rights and responsibilities and legal issues if they just put things out there that aren't supposed to be out there. But the irony of that's what they do every single day and spend an inordinate amount of time making sure they only put out a product that has been edited. They're now coming into this court and complaining that the state of Florida, who has a huge responsibility to the administration of justice, as you know, the Supreme Court has called us ministers of justice, and that's the second irony. We are bending over backwards to protect Michael Dunn's right to a fair trial, to protect this case, to allow it to be tried in the venue which is prescribed by, which is, this normal venue for our circuit, where we need to be, where our victim's family has a right to be. To have this case tried in Jacksonville, Duval County, Florida, without the interference of jurors seeing things that will never pass the filter that we call the rule of evidence. The irony of that they're demanding of us an unfiltered product for them to use as they wish, it's stunning to me. Because the law does allow us to edit this. The public records law is not, as Mr. Gable has represented now for the 4th time in this courtroom, suggesting to this court that we only offered to redact hundreds and hundreds of hours of audio tape statements of the defendant, Judge. Statements that have to be reviewed to make sure there are no admissions or confessions. It has nothing to do with the names of the witnesses. Quite frankly, if there were not a protective order in this case, if there were not media scrutiny on this case, but the case was as complex as it is, we had all these media calls, Mr. Franza would have sent the same email to the same reporter quoting the same price. Because we have an obligation under 119 to redact statements or admissions. You would think that someone, at least neutral, would appreciate the fact that the state attorney is looking out for protecting those types of statements so that there is not anything inflammatory in the public before we try to pick a fair and impartial jury. But that's our job, Judge. We're required to do that by law. We would be redacting these records, whether you had entered an order or not. We would be charging the media the same fair price based on that. And the fact that Mr. Franza didn't specifically mention that as an aspect of redaction doesn't change the public records law. So if you vacate your order, if you say we no longer need to protect the identity of the witnesses, we are still going to quote them the same price we quoted in the prior email, saying we've got to go through every single phone call to make sure we comply with our obligations under Florida's public record law. So we'd be in the same position, whether this case was high profile or whether there was no protective order about the witnesses' names, we would still be doing the same thing, Judge. And as far as summaries go, those are our work product. They were done under my direction with specific instructions to my paralegal on what I wanted in the summaries. I have that right under Florida law. They are not subject to the public records, and we do not intend to turn those over. Judge, we don't believe that those are any business of the media for them to look at what we have pulled out and determined has great importance. So we will not turn those over, Judge. And the second thing is, again, for the clarity in this case, things have been stated in motions by the interveners that simply are not true. And I would like to somehow, if you would allow Mr. Franza to just clarify some things about the public records, because as you said earlier, it seems that we're battling with the media. We're not battling with the media, Judge. We believe they have a right to publish this information, but it's the timing of when they want to publish it that we have an issue with. And it's also the fact that they expect and have said, at least on 4 occasions now, we're not supposed to be redacting anything. I couldn't disagree with Mr. Gable any more strongly than I am right now, because we do have an affirmative obligation to redact. So would you allow Mr. Franza to just clear up a little bit about the public records procedure, because we believe that there are things in the motions that have been filed before this court and before the First District Court where we couldn't be there to say, no, that's wrong, and where we saw an order entered before we got to file the response. But I think now we file a response and then they enter another order. Is that what I was, do I understand they enter the second order now?
Well, you're right. Interestingly, and this was something I was going to point out, sometimes, and this gets lost a little bit, one, the court obviously is very, very limited in the things the court can say about an ongoing case. Lawyers frame their arguments for their clients as they should. That's their job. But in some instances, particularly some types of appeals, an argument can be made to the District Court of Appeal, for instance, and it's only from one side. The other side doesn't really get to respond, which has happened in this case. So that's, I guess, what you're alluding to. And that happens. That's just the way it works sometimes. Yes, the only order that's been entered most recently, quite frankly, was there has been an order from the district court based on your, maybe not so much yours, might have been Mr. Strola's, your motion to clarify, I think, and Mr. Strola also filed a motion to, I've forgotten exactly what he called it, raising
a motion to modify and then a motion to clarify.
Okay, motion to modify, motion to clarify, raising the issue that I had set this matter for hearing on Friday, even though the District Court of Appeal said I had to have an order out by Wednesday at 4 o'clock, thus the reason for this being called so quickly, thus the reason that I amended my notice of hearing to include these motions, because it just has to be done. Well, and I was waiting a little bit this morning to see if the DCA was going to respond, And then when they didn't, that's when I amended my notice of hearing to include everything for today. And then, ironically, shortly after that, I did get an order from the DCA. The DCA has extended to some degree, not necessarily the hearing. They've said that I can take until Friday at 4 o'clock to enter a written order. I had until tomorrow. Now I've got until Friday to get a written order in. I could have, I suppose, pushed this back to Friday. I didn't think that was prudent. I want to save Mr. Strolla a trip up here, which we'll talk about later if necessary, so he can concentrate more on the trial itself rather than these issues. And, oh, by the way, I didn't really think having the hearing on Friday and then trying to, and not knowing exactly how long it would take, wasn't so sure that I could get an order out, a written order out by 4 o'clock. I'm just, I should say it, we're on TV. I like to say I'm good, but I'm not that good. But I do have people helping me, and they're that good. But I don't like to put that kind of pressure on folks. So that's the only thing that's happened is the order could be entered as late as 4 o'clock on Friday, but we'll see about that. So, Mr. Franza, I'll give you a couple of moments to clarify what you'd like to as far as the public records and the public records law are concerned.
Thank you, Your Honor. Please support. The basic procedure for public records requests, and I believe Your Honor has seen the exhibits that the state has provided in response to the intervener's motions. There's a very back and forth about how public records request is done. It can be done over the phone, via facsimile, email, via letter, however method of communication the requester would like to use. We put in the request, we acknowledge the request, we put it in line, and then we get to it. And that's basically what happened here. Simply, the exhibit J is an email that was sent to the Florida Times Union regarding the jail calls. And I believe those are the only thing, and thank you, counsel, for minimizing and limiting what the issue, the public records at issue are, would be just the jail calls, as the state has provided all the other records pursuant to requests. The timing, 185.8 hours. Now, again, that's as of, the date is October 21st, 2013. So there, I believe there are more jail calls at this time that the state has reviewed, but maybe I didn't have copies of them, or maybe they weren't turned over. But as far as reviewing, it's only 185.8 hours that are subject to this. And if you multiply that times 1.5, now we have to listen real time, and we have to listen for bank account numbers, we have to listen for social security numbers, we have to listen to substances of confession. The bank account number is exempted pursuant to chapter 119.871, subsection 5, subsection B. Social security numbers are exempt pursuant to subsection 119.071, subsection 5, subsection A. Substance of confession, exempt pursuant to 119.071, subsection 2, subsection E. Those are just 3. There are hundreds of exemptions in the public records law that may also, we may come upon something else that may apply. And we have to know this information, and we have to review this information. So it really does not negate our need to review. The review was not just for the order. So I just wanted to put that as well. The state has not received any deposit, and I did even offer to let the requesters request less and a lower number of jail calls so they could reduce the cost. And they did have the dates of calls that they could request one call, but that has not been done.
Thank you, ma'am. Ms. Corey, let me just ask this. Does the state, not that this necessarily matters, but does the state intend to use any of these calls in their case in chief?
Judge, right now we have under consideration a few of the calls that we may use, and of course there are continuing calls, so we still have a few to look over. And I do have supplemental discovery for Mr. Strolla just with regard to things we gave him last week when we saw him down in Palm Beach. Yeah, last week. And so I do have to supplement the discovery, and one thing I'm going to make sure of is that there's an end to this number of calls. But quite frankly, Your Honor, we've used phone calls in our case in chief that came up after jury selection in other cases. So I can't make that commitment to the court. I can only say we are considering using some of them, which I would think would be somewhat make it somewhat obvious that some of these may have overtones of a confession, an admission, false exculpatory statements, for example. That's not something that the public generally understands is a confession under Florida law. But that would be another thing that we may need to use for if it were to become a false exculpatory confession. We are going to put Mr. Strolla on notice, and I think Mr. Guy already has sent him some of the ones that we may intend to use to try to help him streamline his trial preparation. But I truly can't answer that for the court right now. I can only tell you, again, that even if this case had zero publicity, even if there was no protection order, we would still be going through the same procedures day in and day out for public records, whether it's a closed investigation, a pending petty theft, or an important first-degree murder case. So we are going to continue to do that because we don't see anything in the district court's order that says you turn everything over to Mr. Gable that he wants. We simply aren't going to do that. That's not what the law requires of us.
One other question, do you ballpark, how many phone calls are we talking about? Just pure number, not time. I know it's 185 hours, which is a lot.
Judge, we can look on I think my second supplemental discovery had gone through, I can't even remember. There's so many. There are just hundreds. There are
Judge,
hundreds
it's several hundred phone calls, including hour and a half to 2 hour jail visitations that I have to go over as well. These are not just 15, 20-minute phone calls. There are several hundred of phone calls, including dozens of visitations, Your Honor.
And I detailed those in the discovery response, Your Honor, because we didn't realize that jail visitations come in on the same disc. So what we've given to Mr. Strolla are discs that correspond with time periods, and it says phone calls or jail visitations. So the phone calls are 15 minutes in duration if the person uses the entire amount of the jail call. Almost all of them are that length, and then there are just numerous. I mean, we think, yeah, and this isn't with the new discovery. There's 740 calls that we would have to sit down and listen to every word that's uttered to make sure that there isn't anything we're not supposed to be producing.
So out of 740 calls, you may consider using 6, 8, 10?
Maybe 10 at most, I would say, but still, there may be something even there we have to redact for the jury. You know, we may not even use all of the call. So assume that it were going to.
And of course, you might not use any because I might rule that none of them are coming into the trial.
And Judge, that's why I admit that's exactly right. That's the point. The reason that confessions and admissions are exempt, as far as I understand, is because if the state were to go out and talk about all this stuff and say, oh, we've got a really strong case against this particular defendant, not this, but I'm speaking rhetorically now, and talk about what we have, what's been furnished in discovery, and then there's a motion to suppress, and the court suppresses all the statements that have been publicized. Or assume the state attorney doesn't make any comment, but just turns it over to the media and they publicize it. You know, defendant so-and-so confesses to doing this, that, or the other. That's a headline that a jury may never hear. That's, again, why the rules of evidence are the critical filter for what a jury will and will not hear. And again, I want to make it clear, no matter how many times the media tries to portray me as someone who's trying to either, quote, hide evidence, which they've accused me of, or trying to keep them from getting all this information. I'm not trying to do either. The evidence will be in a full and public courtroom as is required by our Constitution, and we're only talking about the timing of when they get it.
Well, that's the, yes, sir, Mr. Gable. I see you standing up. Sure thing.
May it please the court,
Yes.
a couple of things I'd like to respond if I could. Mr. Strolla said we have not presented any evidence to show that these phone calls, these jail calls, would not harm the defendant. I think it would be fair to say that if the state attorney is
I don't think that's your job.
What, to be fair?
No, I don't think it's your job to show evidence that it wouldn't harm the defendant.
He's reversing the burden, right?
You got that right.
Thank you, Your Honor. But he has presented no evidence. He suggested something about judicial notice, but didn't say what you should take judicial notice of. Talking about his motion in paragraph 12, that the existing and future discovery materials sought to be protected are as follows. A, any and all jailhouse conversations of the defendant, including but not limited to any and all discussions, phone calls, and or visitations, but he cites no ground for why those should be excluded, no exception to the public records law. With regard to Ms. Corey's comments, she said it was ironic when she referred to the media, but it has occurred to me that it is ironic that the jailhouse letters that first brought all of this to your attention were released by the state attorney with no effort to try to keep those letters from coming out. And I don't know if anything was redacted from those letters, but at least the letters came out. As far as what was requested, I didn't quite understand what Ms. DeFranca was saying, but in the public records request on October 28, Mr. Hannon from the Florida Times-Union requested all discovery furnished by the state to the defendant to date in this case, and Heather Crawford from First Coast News said we would also like to review jail calls made to and from Michael Dunn and a list of the visitors he has had. So to say or suggest that they have to start from scratch through all of these calls is an artificial barrier. I have a copy of the transcript of the hearing on November 7, and page 22, Your Honor said, so you have gone through all 180 hours of these calls. Ms. DeFranca said, no, we haven't. Ms. Corey said, she hasn't, we have. Ms. DeFranca said, sorry. Ms. Corey said, you mean for public records? The court said, actually both. So you have for discovery purposes? Ms. Corey, yes, sir. The court, you've listened to them all? Ms. Corey, well. The court, your people? Ms. Corey, my intern has listened to all of them and given me a briefing on them. And the court said, a synopsis of what's on these calls? Ms. Corey said, yes, sir. So to say that they would have to start from scratch is creating an artificial barrier, really, to charge the full amount. They know what is in the calls. They may have to do some redactions. We understand that there has to be a reasonable charge made, but not for going from the beginning through all the calls.
I see, oh, all right, thank you.
Thank
Mr.
you.
Abel.
Thank you.
Wait 1 second. Mr. Burke.
Briefly, Your Honor.
Sure.
And please, the court, thank you, Judge Healy. Just wanted to respond to a few of the points made, both by Mr. Strolla and by Ms. Corey. Mr. Strolla, I think, suggested or at least implied that something untoward had been done by Channel 4 by publishing a copy of the motion to continue. If there was anything in the...
I didn't take it that way. The way I took it, maybe this will help, was that he was, and again, this is something that is new to me and completely, I'm sure, unknown to the public, is e-filing of documents, which the Supreme Court has mandated first in civil cases and now moving towards that in criminal cases. So, in essence, somebody like Mr. Strolla, who's in another town, can file a document with the clerk of the court here via what they call an e-portal. Not really sure about all that stuff, but he just hits a button and it sends it into space and it eventually winds up with our clerk. As I understand it, it then goes into a queue because hundreds and hundreds and sometimes thousands of documents are coming in by e-filing at a time. And so it goes into a queue, and the clerk takes them in order and starts pulling them out of this queue and actually filing the document with the court. So the document, while it got sent through this e-portal, is not truly filed with the court until the clerk pulls it out of the queue and puts it into the court file, if you will. And I know you know about these things, but just so, you know, if anybody who's interested would know, what was unknown, I think, not only to the court and perhaps to some of the lawyers, in fact, from what I understand, it was unknown to some of the IT people that when an e-document is sent by, in this instance, Mr. Strolla, the e-portal has information about that case already. And it already has Mr. Burke's name, Ms. Corey's name, Ms. Wolfson's name, Mr. Gable's name, might even have my name. It may have a variety of names, other co-counsel of Mr. Gable and Mr. Burke. And now, as I understand it, that document immediately goes to those people, even though it has not technically been filed with the court. It's now out there, and this is again ironic, because there's no telling what could be in it. It's now out there kind of in cyberspace, if you will, and it lands with whoever. Quite frankly, some news media person's name might be in the e-portal, and maybe it would go straight to Channel 4 or to the newspaper. I don't know. So I don't think he was saying that there was something untoward about it. I'm gathering it was, you know, just a bit of a surprise that the document was e-filed, and within 15 minutes, and this is just the nature of the way the world is going, within 15 minutes, not only was the document on the internet, but your people were pretty good, and they made a little story about it and put it on the internet. And it wasn't for several hours that the clerk actually, in this instance, pulled it out of the queue. Otherwise, it would have been even longer than that, and quote-unquote filed it. So it was truly a filed document. That's a glitch, I think, maybe in the system. I don't know. I don't know how that's supposed to work, but I think that's what he was referring to.
Well, Your Honor, I appreciate that, that review of it, and your impression.
Does it sound correct?
Well, I think it is, and your impression is what matters to us. There is part of that process, I don't know it precisely, but there is part of that process that guarantees or protects documents that contain confidential information or information that might be subject to redaction, not necessarily information that is subject to an order, but just might be subject to an order. It's the filer's duty under Rule 2.420, as you know, and under 119, to bring to the clerk's attention using a form. There are 19 statutory or enumerated categories of documents that are exempt, or just a generalized motion to determine confidentiality of records that should accompany or be the cover sheet on the document that the filer wants to have reviewed. So there was nothing about that motion that indicated there was confidential information in it. And frankly, Your Honor, I think you do accurately describe the process, at least as far as I understand it. But it's no different from the email service that we've had a year or so, maybe a year and a half, that the Supreme Court instituted. And so you're right, the e-portal is an automatic thing that takes care of this very quickly. But in terms of the effect is that, I could upload a document to be filed or send it, put it in the outbox to go have the runner take it over, and then serve it by email, and all the parties would have it before it ever reached the courthouse.
And so I guess, and this is really kind of off the subject, but what I'm hearing you say is that if the sender, no matter who it is, either clicks the right box or has some cover sheet that says, I'm hoping that the clerk and/or the court is going to look at this and determine whether or not some of this is confidential. It still goes out to quote-unquote other lawyers or parties. It's kind of on the, well, as officers of the court, then you would not disseminate those types of things. I don't know if it goes to civilian parties or not, who are not subject to our rules. But it's kind of, I guess, the honor system at that point that something doesn't then get disseminated if there is a caveat that's obvious that it should not be until a ruling is made.
I think that's right, Your Honor. I don't know, technically speaking, if, and there is a place on the e-portal to designate if the document being filed contains or should be subject to confidentiality review. There is a place to check a box, as you say. I don't know if upon doing that, the document would be served right away by email as the non, I don't know. But you're right, if a document said, you know, motion to determine confidentiality and contained information, it shouldn't be disseminated until heard by the court. It's a little bit hard to, well, I want to make sure Your Honor understands, and I won't speak for my colleagues at the other media, but I think they're on the same page as we are. We're not asking for documents just to be handed out willy-nilly, tape recordings. They have to be reviewed or redacted. You know, the one way to read the DCA's order, I think, is that they should be released. But, you know, we understand, and the state attorney has very nicely confirmed my point for me, that whether there was a public records request or not, she would be reviewing these tapes for, you know, the specific exemption for substantive confession, or there are 4 categories of information that all filers have to be wary of: Social Security numbers, bank accounts, birth dates, I think, and there's a 4th category. And it's the state's obligation, the custodian's obligation, to review those documents so that that information doesn't make it into the public record accidentally. Moreover, Chapter 119 in the case law construing it says that an agency, a custodian, certainly can recover actual costs of complying with a public records request, but the custodian cannot recoup the cost of doing business through charging for a public records request. So in this case, we would say, Your Honor, that if the state attorney has already gone through, for evidentiary purposes, substance of confession review, has already gone through for those other enumerated information, Social Security numbers, et cetera, that should not become public without a specific reason. If they've already done that as part of their duties as the state attorney, they cannot now come back and charge the requester to recover or recoup their cost of doing business. All they can recover is the actual cost. And I'd be glad to provide case laws that I can, will support that point, Your Honor. So we would say if the state has done that, they really can't charge us for it. Only to the extent that they do something that wouldn't have been required for their custodian duties and evidentiary purposes.
I see Ms. Corey. I'm sorry, Mr. Brick, you.
That's okay, Judge. I know Your Honor knows that admissibility is not the standard.
No, it's not. It's, again, and that's one of the, it's not irony, that's one of the conflicts that, you know, some folks would say that what should be out there would be only things that would be admissible in a trial. Others would say, no, it can be more than that. And quite frankly, clearly, the state of where we are now is it's more than that. It's not just what comes in a trial. But that's just where the law is.
Thank you, Your Honor. Thank you, Judge.
I'm sorry, Mayor, again, I have to clarify 2 things. I didn't review these tapes or have my paralegal review these tapes for public records purposes. I'm trying to get ready for a criminal trial. And I'm doing that the way I've done it for 32 years. It's my obligation to look at everything, to figure out what we're going to present in our case in chief, to figure out what we may need for rebuttal, if the defendant takes the stand, if he doesn't take the stand, if anything else comes up. And the other thing, so these have not been reviewed for public records purposes. I would be the person sitting and doing that, I'm sure there'd be some headline story that I spend all my time listening to jail calls. But beside that, Mr. Gable just mentioned, why would the state attorney release these? The media starts their stories off a lot of times with the state attorney's office released documents. And I believe, and correct me if I'm wrong, Your Honor, but I think even one of the district court panel asked, why would the state attorney release these? First of all, we don't release them like a media release. We don't do that. We comply with Florida's public records law. And so to clarify the confusion about what somebody can access on e-filing, the reason that there was an issue with admissions in a different case is it was contained in an arrest docket that got posted unredacted, because the clerk does have that entire document. But for purposes of the Dunn case, the clerk gets a copy of our discovery response, which gives an inventory of what we've turned over to the defense. So the clerk doesn't have copies of the phone calls, copies of the letters, or anything else that the media may wish to request through a public records request. So they're left with requesting that information, the specifics, the actual calls themselves, the actual body of the letters themselves from the state attorney's office. Once I furnish it in discovery, it becomes a public record subject to redaction. And that's what we've done. We've complied with our public records law. We're not releasing this so that the media can publish it to someone. We would have never turned over those letters had there not been a specific request for them. So we are caught in the middle where, had there been something in those letters, we would seek protective order. We would have come into you with copies of the letters as evidence saying, we check this. I understand we're now in a position where we have to come to you and present evidence. And again, I'm going by what we discussed based on what the DCA has asked you to do. And Mr. Stroll has got to present evidence, and we have to present evidence with regard to the phone call.